start today to talk about pre-court investigation by the Department of Children and Families, and actually it will also connect to some of the care protection cases as well. Let's see. Where's my state side?
You switched all around. We're parent now. We used to be state. So we're parent.
Or child.
You guys are to my right.
This side's child.
Yeah. So Joe, suppose you're a school teacher, and Amanda is 11 years old. She's one of your pupils, and she comes to school with some bruises. Okay, bruises on her arm, and so it's been sort of over the period of some weeks. She had some bruises. You asked her what happened. She said she fell off her bike. Second time you asked her, she said her dad hit her. Okay. What are your responsibilities, if any?
I think I'm mandated to report it to the state.
Okay, so what does mandated mean?
It means it's mandatory that I have to.
Speak up.
Oh, it means that it's I'm required by the state to report.
Okay, can you elaborate on that? But from the reading of the statute that you have for today. So everybody take a look at the definitions in section 21. And the particular definition of mandated reporter.
Okay, so I have to file a 51A report. I'm an advocate.
Okay, before you get the 51A report, what's a mandated reporter? And I like to put it, because it's one of the longest sentences in the world. And it contains different categories of what we call Massachusetts mandated reporters. Joe is correct. First category being medical, physicians, hospital personnel, EMTs, dentists, nurse, chiropractor, podiatrist, etc. The next category of which Joe would be in, right, is your educational facilities, your teachers. Third category is probation, people in the courts, parole officers, social worker, etc. That's the third category. The fourth is actually the newest category is the fourth, the priest, rabbi, clergy member contained in that category, with some exceptions, in terms of priest penitent privilege. We're not going to get into that right now. And then people in charge of actual institutions, medical, private, and lastly the child advocate. So number one, Joe is a mandated reporter, and he has some duties being a mandated reporter relative to whether a child has been abused or neglected, right? Everybody following me so far? Stop me if you have questions, because I'm going to be sort of all over the place. Just by nature of the fact that we have, and I mentioned that first class, we've got statutory law, and that's contained for the most part. We're looking at 119 right now. But we also have administrative law, because DCF being an administrative agency has its own rules and regulations contained in 110 CMR, the Code of Mass Regulations. And then we also have case law that sort of interprets, right, the statutory law as well. So what is Joe guided by specifically in terms of whether he should report a case of abuse or neglect? Where do you see the definition of abuse or neglect? So in this case, let's look at, he thinks that Amanda might be abused by her father, right? What's the definition of abuse? What's going to guide him as a mandated reporter to determine whether in fact her bruises constitute abuse? Did you see that anywhere in the statute? Because I gave you actually the statute for reading, as well as a pretty old but still applicable article written by me and Elder that kind of explains the process, and also cites in it what used to be called DSS, now DCF regulations. So,
Yeah, it
Michael?
defines abuse in the regulation.
Yes, you're correct. So the definition of abuse is contained not in Chapter 119, but in the DCF regulations. So I'll just read it to you, and we'll talk about whether everyone thinks, in the hypothetical that I just gave you, do Amanda's bruises constitute abuse? The non-accidental commission of any act by a caretaker, and we'll talk about what a caretaker is at some point, upon a child under 18, which causes or creates a substantial risk of physical or emotional injury, or constitutes a sexual offense under the laws of the Commonwealth, or any sexual contact between a caretaker and a child under the care of that individual. So, Joe, if you want to continue the discussion, knowing now what the definition of abuse is. So it's 110 CMR, somewhere in section 2, I forget exactly. Okay, let me give you something else to guide you a bit further. By what standard does Joe have to be satisfied that there is some abuse? Let me see if I asked this correctly. By what standard does he have to follow as a mandated reporter to report to DCF that Amanda is abused? Laura?
A reasonable cause.
Okay, and where are you seeing that?
That's any other person.
See, this, I hate this statute, I hate it and I love it. What section are you reading?
Actually, I took that from the 51A report.
Okay, you just said it, 51A. So everybody jump to, if you have it in front of you,
It's in subsection A.
119, section 51A. So we already got the definition of abuse. We have the definition of a mandated reporter, right? And now we're looking, and I hope I printed mine out. I think I did. Hold on, so I can turn to it too. 51A. Okay. Now 51A, all 51A is a reporting statute. That's all it is. It's a reporting statute. So section A starts with Joe's situation. We have a mandated reporter. He's Joe. His professional capacity, right? Amanda, his pupil, he sees her every day. He's teaching. She says her dad hit her. And as Laura just pointed out, reasonable cause to believe that a child is suffering from physical or emotional, in her case would be the physical injury. That standard reasonable cause, we're going to see in all over the place. We see it in the statutes, you're going to see it in the regulations, you see it in case law. If you had to explain, though, what it is in terms of a standard, right? What does it really mean, reasonable cause? Or in terms of, a continuum of, say, 1 to 10, right? Where would you put reasonable cause?
More likely than not.
More likely than not?
Yeah.
Where do you come to that? He just said more likely than not, which is similar to a particular civil burden of proof.
Well, I mean, just
Right.
from what I read, it seemed like the reporting part required a more likely than not that it happened, but then the actual finding
Okay,
of
but
abuse requires a
where
higher.
you normally see the language more likely than not? You guys have read, you've had torts, you've had contracts. What's the standard for civil cases?
Preponderance of the evidence.
Preponderance of the evidence. So on a continuum, Beyond a reasonable doubt would be up to 10, say. Preponderance might be somewhere at around maybe like 6, because there's something else in the middle. Reasonable cause is below that. It's a very low, maybe it's a 2 or 3, I don't know.
Okay.
Very low threshold burden of proof. It's like going to get a restraining order, for example, an injunction. Very low burden of proof. And why is it a low burden of proof? Think of the reasons why someone would get a restraining order injunction. Jim?
They say that the reason why it's such a low standard is the protection of the child.
Yeah, someone, whether, again, someone, restraining orders, injunction, it's an emergency sort of situation, someone might be in danger, we're talking about, sort of police power situations, etc. So it's very low reasonable cause. That's all he has to have, reasonable cause to believe that Amanda is suffering from physical injury. And then it outlines, whether it's abuse, neglect, etc. What does he have to do next? We're still in 51A, Section A now. So say Joe feels he's got reasonable cause to believe that Amanda is being abused by her dad.
He's going to call the department, DCF, and report it.
Physical abuse. And it's important dad, because dad also meets the definition of a caretaker as well. What did you say, Michael? Were you answering?
Yeah, he has to call and report within 48 hours to the department.
So she'll file a written report with the department detailing the suspected abuse, or neglect. So
You have to call right away, though, and then file within 2 days, right?
we'll talk about the time period in just about a minute. So Joe is a teacher. He believes, has reason to believe, that Amanda is being abused by her dad. Okay, so he's having the conversation with her at 1 o'clock before school is up. Okay. The bell rings and he's got a couple of minutes, or it's lunchtime. What's Joe going to do?
I'm going to go call.
Is Joe going to call?
Well, maybe the principal may.
Yeah, so he's going to be, all right, so there's sort of the level of administration that he has to report to as well. So he's probably going to confer with whoever his immediate superior is, principal, vice principal, etc. And then they are going to call, okay? And then they will follow that up with a report. The call is the first instance when DCF, say this is the first instance DCF is hearing about Amanda. We'll talk about maybe they've heard about you in other contexts as well in a moment. When DCF gets the call, so far we've been with the reporter, right? 51A and we were looking at section 21 at CMI, 51A, the reporter. Now DCF gets the call, and then there's a sort of an immediate decision that DCF has to make. So DCF gets the call, reporting on Amanda Phillips, 11-year-old student of such and such school, blah, blah, blah. I've heard from her teacher has just observed her, blah, blah, blah. And whoever the caller is, more than likely Joe's supervisor is talking to DCF on the other line. DCF, the screener, and here's the hint, the screener has some decision, has two sort of calls to make. Screen in or screen out, right? Suppose that Amanda, in fact, did have bruises, but she's, 15 and a half. And the bruises were inflicted not by dad, but by her boyfriend. not covered by the statute. It will be screened out, the boyfriend is not a caretaker. There might be some recommendation in terms of police, district attorney, et cetera, but that would be a clear case of screen out and no further action, right, by DCF. Say it's multiple reports. I don't know, just forgot that the homeroom teacher had already reported it, whatever, same incident, etc. Let's assume it gets screened in, because that's where now DCF's duties start kicking in. And what we're looking now at is 51B.
Can I just ask a quick question
Yeah.
about when Joe is going to make the call?
Yeah.
That's only just sort of an administrative part of the school and how they operate, that he has to go through the principal. He could actually call himself.
Yes.
He just
yes.
may be violating
Yeah.
school policy.
Exactly,
Okay.
exactly, yeah. There was something else I wanted to say, hold on a second. No, I'll remember it. Yes, there was. So at some point, you're going to get confused because you're going to think that every 51A that happens results in a parent protection case. You can have DCF, you can have 51As being reported for years. You can have DCF investigating under 51B, multiple reports again for years, coming up with, decision to support the initial 51A report, offering services, etc., without DCF actually filing a parent protection case. So I am going to be talking about the instances when they do file, because that's the case, that's basically the case law. But remember, the DCF services, the reason for DCF is to, and that's described in the purpose clause of not only the statute, 119 section 1, but also the purpose clause of the Code of Mass Regulations. DCF is an agency that was set up to, quote, strengthen and encourage family life, give families, services so that they could be, helped in terms of, help them through instances that for whatever reason, parents are unable to care for their children temporarily. So again, you can have DCF engage with a family for, maybe years without DCF, for whatever reason, having filed a CMP, a parent protection case. Yes, Nicole?
Now, don't you kind of run into problems with this? Because right now I'm appointed to 6 children who are siblings, and
Yeah.
15 51As were filed on this family for sexual abuse, weapons, threatening. I mean, it was all there.
Over years, you're
Over
saying,
years.
before DCF
Before
filed
DCF, well,
a...
it finally became so abusive that the children were removed from whatever. But now DCF was involved with this family for years before they actually decided,
Yes.
okay, you're being abused enough to be removed. Now,
to be removed, or for us to file a parent protection
right,
case.
but you
asking for
have,
custody.
I mean, if you have a child who's complaining, she's being sexually abused. If you have a child who's complaining, the father's bringing home hookers and having, sex in front of
Yes.
his children. I mean,
Yep.
that's all reasons for them to remove. I mean, their safety was clearly. So why wouldn't
And you're
DCF step
struggling with
in?
why didn't it happen years ago?
Yeah, I mean, isn't
Yeah.
it kind of a disservice to the children when DCF doesn't step in?
Absolutely could be.
So
You know,
can't
and
you
then there
file
are
something on
instances when
DCF?
DCF acts the other way in terms of removal. Now remember that what has become sort of the framework for us to discuss these cases were these parental right cases that we looked at. That for the most part, the state is supposed to leave families alone. The state is supposed to leave families intact. The state is supposed to, again, under these regulations, statutes and case law, work with families before making the god-awful step of removal. Even children who have been abused terribly and neglected terribly, 99.9% of the time do want to stay home. But I hear you, and that is probably a really sad case, Nicole.
Now, were
Yeah.
each of those 15 51As supported or were they not supported? I mean, how?
DCF claimed, well,
They-
there was a case where the father, and again, like, this is not something that people should be sharing, so I'm not going to be giving any names or anything
No,
like that.
absolutely
But the
not.
father put a gun to his child's head and threatened him and said, if you tell anybody that this is true, I'm going to kill you. And he recanted, and DCF said, okay, he recanted, so there's nothing we can do.
Yeah.
Really?
Yeah.
You know, at that point, when do you step in? You know what I mean? When do you realize DCF is not? They're just closing their eyes because they're so overworked and they're so whatever.
One of the cases that Nan Elder mentions in the article that I gave you is actually a really old case because it was before the Mass Tort Claims Act. You know, that you can now, you can sue an employee of the state, but there's that cap of, I believe it's 100,000. Well, in Manley v. Casey, this young girl, I was using Amanda as the example with the bruises. Well, she kept coming to school with god-awful, like, injuries. And there were 51As, and there were 51As that were supported back then. It turned out, and I forget she lived with one bio parent in one step, I forget which was which. And then the other bio parent, lived in another state. So the abusing step-parent ended up beating her so bad that she went into a coma. The bio parent from the other state came and actually sued, everybody, the school system, DSS at the time, blah, blah, blah. The appeals court of Massachusetts said that there was no liability and actually quoted 51A and a really famous quote in there that not every bruise, they said, needs to be supported. Said what it was a terrible case in that respect, but that DCF that DCF couldn't really predict the near fatal injuries exactly that the child had. So keep that in mind again in terms of this hypothetical, and it certainly starts the ball rolling if the teacher is going to be reporting to DCF, but then DCF is supposed to be following the law in terms of its duties under 51B. So let's take this further. It gets screened in, okay? In this case, it's going to be screened in as a non-emergency. She just has some bruises. Under 51B, and I just lost my place on it, but I believe there's a time period, right, for the non-emergency. I think it starts in 2 days, it's final in 15 or something like that. Yeah, it's 51B, section D. So what's happening is, gets screened in, worker gets the job of doing the 51B investigation, correct? What do you suppose that worker will do? So that worker will speak with the Joe, perhaps, all right? Go to the home, speak with mom, speak with dad, speak with any collaterals, look at medical records, if any, look at educational records, if any, and then come up with a written conclusion as to that first 51A report. And the conclusion is that the worker now has reasonable cause to believe. So there's reasonable cause for Joe as the reporter to report, and reasonable cause for, say, Nicole, at the conclusion of her investigation, to support that 51A. And so say she's come up with this in a week, okay? So a week has transpired. What happens next? And again, we're just looking at the agency situation. So what happens if she just did an investigation, now there's going to be an assessment worker, sort of a bigger sort of looking at the families, but I like to think about it. In order, again, remember this department is looking at how do I help this family? How do we give the family services? How do we stay within our stated purpose of strengthening and encouraging family life?
You're talking about home visit?
Yeah, a bigger look at, so Nicole was just investigating. Nicole came up with a conclusion. Her conclusion was to support. Right? Now, a bigger look at it, I think it's like 10 days after, something like that, right? And then 45 days after that, you now have your first of maybe many service plans for the family. So again, I'm just talking about agency stuff right now, what the agency is doing. So almost, you're talking about 40, that's more than a month, right? A month and a half has passed. Now, because it's an agency, it's not only, come up with and following its regulations, definition of abuse, services, etc., but it also can be quasi-judicial. So, for example, Amanda's parent finds out, gets notice that Nicole supported the 51A report. Does Dad have any recourse? Gets notice. 51B investigation is over. The initial report by Joe, the school teacher, has been supported by this office. This is your notice. Your notice to the parents. Okay? Due process, right? Can parents do anything? This is probably not in your readings for today, but just think about it in terms of parent got notice of an agency decision. An agency is quite like a court, quasi-judicial.
I would assume they could have some sort of appeal with the agency.
Absolutely, and it's actually, have you ever heard of the Administrative Procedure Act in Massachusetts? And I don't know if you encountered it in other classes or not. It's Chapter 30A, I believe, of Mass General Laws. You have a right now as a person in this process, right, to appeal that determination by this worker. So while DCF is coming up with determinations, they're not all final. It's not often that parties do, avail themselves of appeal processes within, but, many do. And it runs, if there is court stuff going on, it runs sort of parallel to that. Have you heard the term, exhausted administrative remedies? So you can go through administrative appeals and ultimately even go to court to appeal what an administrative agency has determined. So kind of keep that in mind as we're sort of discussing what DCF might do in Amanda's situation. Okay. Okay, let's make it an emergency. Suppose that let's make it a non-mandated report. Suppose that Michael is your neighbor, Laura, and he hears you and your husband fighting all the time. So lots of hands, you get kids screaming, etc. You've had it. Finally, you call the police. Right? Jim gets the call. Okay. Jim and his other Amanda, Amanda S, partners go out to the house. Right? And you find Laura looking sort of looking bruised.
Am I the wife or the child?
You're the wife. I'm trying to figure out if I want your husband there or not. Yeah, okay, so yeah, your husband's there. He's been drinking, he's ranting, raving. 2 little kids are in the bedroom. Jennifer and Jonathan. 5 and 4. 5 and 3. Okay. And Jennifer's sort of, taking care of Jonathan. Jonathan's crying a little bit, etc. So, you walk in the house. Amanda, maybe you're talking to Laura, or maybe you walked through and you looked in the bedroom. Jim, you're probably, arresting your husband. Actually, I changed it because you're a non-mandated reporter, okay? Amanda and Jim are what?
Mandated.
They're mandated reporters. Why are they mandated reporters, and why would they be calling DCF? There's no physical injuries as to Jen and Jonathan, but they're in the bedroom. Jonathan is crying. Laura is
Well,
really
witnessing
physically
the abuse of the parent could be emotional abuse for the child.
And we'll be getting into that in the later weeks when we study some of the domestic violence cases. So assume that now, Jim and or Amanda, you're going to be calling somebody from DCF. And you're going to call them right away because Laura's husband's getting arrested. Laura might even have to go to the hospital. So for whatever reason, you're calling DCF. Laura might be saying, no, I can take care, I'm fine, blah, blah, blah. But you determined that you think you have reasonable cause to believe as a mandated reporter that these kids fall within, and let me read you actually the definition of neglect, if I can find it.
It's on the second page of that article, Lauren.
You want to read it,
Sure.
Michael?
Neglect, according to the department, means failure by a caretaker, either deliberately or through negligence or inability, to take those actions necessary to provide a child with minimally adequate food, clothing, shelter, medical care, supervision, emotional stability and growth, or other essential care, provided, however, that such inability is not due solely to inadequate economic resources or solely to the existence of a handicapping condition. This definition is not dependent upon the location. Neglect can occur while the child is in and out of home setting.
That's fine. Okay, good. So, who haven't I named so far? Who's the work? Okay, so Nicole gets the call. Nicole gets the call. So that everything that I've said so far in the second hypothetical fell under 51A, right? Yeah, Mike, who was non-mandated reporter.
Mike was the neighbor, right? Just-
Yeah. Then you have the cops. They were mandated, of course. Okay. Reasonable cause to believe that these kids might be suffering from at least neglect. All right. They call right away. DCF screens in at that point as an emergency. Because of what they're hearing from, we've got concerns here. We think somebody needs to get out here right away. Because the failure to take any action might create, some substantial risk of injury to these kids. But it's still reasonable cause in terms of the standard that these reporters are meeting. So, Nicole comes to the house. Hopefully and thankfully, cops are still there as well, okay? Because it's a real volatile situation. She does determine that this is an emergency situation that does warrant removal. How is that different?
Can I ask a quick question? So the person receiving the call determines it's an emergency, and then Nicole supports it's an emergency?
Okay, I'll slow down. Person receiving the call screens it in, actually, as an emergency. So remember the screened in decision, it was screen in or screen out. And then as to screen in, two choices are emergency, non-emergency.
Okay.
Because if it's non-emergency, remember it's the longer 51B investigation, the one that takes up to 10 to 15 days. Even the 51B non-emergency does need to get started within a couple of days, but they have a longer time to look at the family because the child is not in danger. So the screener, yes, you're right, the screener is the determiner of there's an emergency, we need to get somebody out there right away.
And that's what starts that window of 2 hours to 24 hours?
Exactly.
Okay.
You're going to get there right away, within 2 hours. The report that I make, whether I support or not support, is going to be within a day because it was screened in as an emergency. Now, here's where it gets tricky. Because it's an emergency, and because the children get pulled. Well, let's talk about first, how is it when parents, we look at the parental rights cases, parents have custody. How is it that an agent of the state can come in and take your children without, because that was just on the call. It wasn't anybody running to court to get a piece of paper that says, you know what, I have an order here for custody, right? What gives the state the right to do what they might do with Jonathan and Jennifer?
Well, isn't it a case of where the safety and well-being of the child supersedes the right of the parent?
So think back to Prince v. Mass. Remember the rationale behind the state, under the child labor laws, finding that even though Sarah Prince had a 14th Amendment right, I know what's best for my kid, and furthermore, we're Jehovah's and we have the right to practice our religion, etc. But the state could show that there was a compelling interest to protect, exactly what you just said, to protect children from working out on the streets, child labor. It's the same sort of rationale, the same reason behind police power of the state. The state being able to, so for the most part, parents are left alone, families left alone, right? Unless there's situations that somehow endanger children, physically, mentally, etc. And this, we're assuming, is that type of situation where the DCF is supposedly following, their rules, their policies, the statute as to what constitutes abuse and neglect, and rightfully had removed children from that situation, at least temporarily. Okay. Before I get to talking about the court stuff, so Jonathan and Jennifer, say it's 10 o'clock, Saturday night when this happens, right? Where do they go? So, okay, they go in Nicole's car, and then what?
Isn't there emergency foster homes or foster parents?
So, what is the reason behind, we know the reason for taking the children. But think about DCF's mandate of families.
Well, is a preference going to be given to local relatives that...
Absolutely, and that's in their regulations. So there's a hierarchy of that DCF has to follow. It might be hard in emergency, but in the end, they must go through. If there are, relatives ready, willing, able, meet the criteria, etc. Placement with family is favored over placement with, foster homes. So that we'll be talking about that too at one point later on. Some of the case law talks about situations when DCF doesn't follow its rules and regulations, and when parties have a right to bring what's called abuse of discretion motions, but that's for when you read the cases for Thursday.
That just seems to make sense. If the kids are already going through this already traumatic enough experience.
Absolutely. Why not go to Auntie Jen or, Uncle Nick?
A place where they're at least comfortable, then, you're with this stranger for the next couple of days till we sort this out.
Exactly. So the other thing is, in my scenario that I just mentioned, well, they're taking Saturday night. Courts aren't open Saturday night, they're not open on Sunday. Now we're looking at the statute that talks about filing a care and protection case.
So they'd have to do it Monday.
Under 50, actually, you jump from 51B to section 24 of the statute. So under 51B, and I forget it's C, section 3 or something like that, if the children are taken on emergency, like the situation that we just talked about, what does DCF have to do?
I know they place them in a hotline.
We just talked about the placement.
Okay.
What does DCF have to do after they've made the placement decision? What else does DCF have to do? So we're looking at 51B E. Anybody have it? And think about it for a second, because remember I said before, well, the cops or DCF didn't have any piece of paper. Now they have to get that piece of paper. How? Nicole?
DCF has to file a written report stating the reasons for the removal, and they have to file a care and protection.
The next court,
Yeah, the next
business day. So now we're looking at 11924, and now we are talking about the court process. So far, sort of everything we talked about had to do with pre-court investigation as well as with DCF administrative processes. And this was just really basic, because we'll get back into this as we describe and look at some of the cases more specifically. 11924 is the section that deals with the start of the care and protection cases, the standards, care and protection, okay. And if you have it in front of you, just go to the third paragraph first of 11924. If the court is satisfied after the petitioner testifies under oath that there is, here we go again, reasonable cause to believe that the child is suffering from abuse and neglect, blah, 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 the court may issue an emergency order. What's that all about?
Like a protective order? Like a restraining order?
So Nicole's gonna go in Monday morning with her petition, with her affidavit, I went to the house, blah, 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 describing everything. This is actually a description of the first, when there's an emergency, the first hearing the court conducts when children are removed on an emergency, in an emergency situation. If the court is satisfied after the petitioner testifies under oath, there's reasonable cause to believe the child is suffering from abuse and neglect, an emergency order transferring custody up to 72 hours. We'll talk about the 72 hours in a minute issues. So remember, reasonable cause was a very low threshold. Right? Have you observed any of these, Nicole?
Any of where?
Emergency hearing?
Yeah. No, but we have had children who have had them in our house.
Okay. Really low,
Yeah.
low. Think of getting an injunction again. Think of getting a restraining order. You're going to court, it's an emergency. Not everyone is there, but the important person, the person that's in need of protection, is there. And in this case, the state, arguing that these are the facts. I removed Jonathan and Jennifer from their home Saturday evening. We're asking for an emergency order of custody. This is the department. This is the department's social worker. At this point, the department's attorney doesn't even know the facts. We'll talk about notice to the various parties in a moment, and if that's what you're raising your hand about, hold that thought. Who is at this hearing, and what exactly does the judge have to be satisfied of? So you came in, Nicole, you filed that morning, because under the statute, you have to file that morning. So you have the petition itself, you quickly did your affidavit over the weekend, you filed it with the clerk's office, you got on the list for that morning, the case gets called, you're appearing before the judge, right?
Yeah. So then the judge would, if I were to give a satisfaction of reasonable cause that the child is at a risk for neglect, then the judge would award DCF custody.
And pretty much that's it. It's the conversation pretty much between me and as the judge and Nicole. In the situation I described, Dad might be, awaiting arraignment in a little district court perhaps or somewhere. Mom might have ran in or not to court knowing about it, or is seeing her lawyer, or is getting medical help, or is talking to other social workers as what to do, etc. But the important participants for the emergency hearing are pretty much only the social worker and the judge. Really low. And again, because it was an emergency, police power of the state sort of is continuing. Judge is satisfied that it is an emergency. Now DCF has custody. Real important. And I forget.
That's a closed hearing?
They're all closed hearings in terms of only
The public.
parties. You know, if Laura showed up, she would certainly be allowed in the courtroom. Okay.
But
if you showed
but
up,
if like the grandmother showed up, not necessarily?
depends. Maybe. Not a party, certainly, though.
And can I ask just one more question? So,
Yeah, I want everyone to, before you ask the question, to look at section 21, because we're looking now at the definition of custody, because now, as a result of this emergency hearing, DCF is getting custody.
so just building on your hypothetical, so dad gets arrested. Now, let's say mom's in the hospital for the weekend. Maybe she had some, whatever. She needed medical attention for the weekend, and the parents are placed with maybe the only
Kids
local.
are placed,
maybe,
you mean?
Yeah, the kids are placed with dad's parents because they're the only local relatives.
Sure.
Okay. It would be likely that if dad was going to get bailed out of jail before the weekend's over, that his bail conditions are going to maybe require no contact with the kids.
Yeah,
Okay.
yeah.
Just to ensure that they're protected
Yeah.
until this hearing.
Custody, the power to determine a child's place of abode. So that's what's important right now in the context of DCF making decisions. Now DCF has custody. Now DCF is the parent. The parent's patriotic philosophy. The ability to decide what's best for the child now is resting in not the parents, but DCF. On a temporary basis, but still. And it goes to other issues as well, medical care, education, controlled visits, we'll talk about that later on as well, visitation issues, etc. So DCF now has custody. So go back to 24. I'm sorry for this jumping around, but it's the statute, it's not me.
Now, does that encompass legal and physical custody?
Yes, yes.
So it's legal and
Yes.
physical.
Well, absolutely. Think of it this way: instead of separating legal and physical, it's DCF has custody, okay, and has the right to determine where the child is living.
Okay.
So you, as a parent, might say, "Oh, you can sleep over somebody to so and so's house." Well, you still have custody. You have the right to call them back from that house. You have the right to say, "No, you're now going to grandmother's house," right? Go to the first paragraph, because that's the petition that Nicole also would have filed. So what gets the ball rolling that Monday morning is a petition alleging any of these situations under A, B, C, or D without necessary physical or educational care. So this is, and by the way, although we keep talking about DCF, and that's usually the petitioner, the statute says a person may petition. So really, anyone can file a parent protection petition. And it's alleging, that a child or children within the court's jurisdiction is A, without necessary, care and discipline, growing up under conditions damaging to the character, lacks proper attention, a parent who is unwilling, incompetent, unavailable. What do you think of the description here? So this is the jurisdictional basis for DCF or a petitioner getting custody of a child. How do you read these situations?
They seem pretty drastic, far end of the spectrum. Like, it doesn't seem to me like it's.
Are they general or specific? Really broad, really general, in which you can fit many different situations of a parent, for whatever reason, being unable at that point in time to care for their child. So it's deliberately made very, not necessarily vague, but very general. So those would be the allegations in the petition. The next paragraph is the notice to the parents. So when we talked about, Jerry Galt, for example, getting notice because his liberty right was at stake, for example, parents here in an adjudicatory parent protection case who have parental rights also need to get notice of what the petitioner is doing, has filed. So parents get notice. Nicole?
We just, my mom is a member of, I think it's called MAP or something. It's like it's the head people that help, like the procedures and everything with DCF. And we now were told as foster parents, we have to also contact the parents by phone. So DCF no longer has to just contact them through writing. The foster.
Say that again, I'm sorry.
The DCF has to contact the parents to let them know what's going on, what's being said against them, or whatever. But now the foster parents have to contact the parents by phone, telling them to say your child is with me, is safe, and the parents are allowed to call the house. Like, how is that even safe?
I have no idea. I have to look at it whether this is a regulation.
It is.
Or
It just passed.
A DCF regulation just passed?
It's DCF
I will ask
with
to find
foster
out.
families. They have to call the parents within 24 hours.
That's interesting. Keep in mind that when we do talk about foster parents, parents is almost a misnomer because the people that how do I put it? The people that DCF places kids with have no parental rights at all. What they have is a contract with the state. They have a contract with the state to take care of the kids. And what's really sad is sometimes they have these kids for such a long time that the kids love them, they love the kids, there's a bond, etc. And it might be looked at, and certainly is, because it's one of the reasons why a kid might be adopted, but in any event, they're not parties to the case. They're the ones that have the kids 24/7, but they're not parties to the case. And again, they just have a contractual situation with DCF. That's it. And so that makes sense. So DCF is dictating to them these are the things that you have to do while you have a kid that's in our custody. You just have the kid in your home.
Right, it makes sense to a point, but to me, the whole point of placing a child in a foster home, when there is no kin involved, is to keep them safe. So like when we get children in our house, we have one little boy who had 15 brothers and sisters in the system, and dad was extremely violent to that child. And so when we got him, we were told that you need to, contact dad. And my mom's like, why would we do that? That risks his safety because dad is violent.
That absolutely is correct, and there's probably a way that your mom or whoever is can not even appeal that, will refuse to do that.
Yeah, but DCF said if you refuse, they'll remove the child from your home. It's ridiculous. It's really ridiculous.
The parent has a right to know where their child is.
They do,
still.
but the child has a right to be safe, and so does
Right,
the
but you
foster
don't give them your
family.
address, do you? Do you like say,
Well, if you give your phone, if you're calling,
Yeah, you
let's say
call
you
a
don't
guy.
have a cell
One at a
phone.
time.
Let's say you don't have a cell phone, you're calling from a landline. It's very easy for someone to look up your phone number and find out where you live.
yeah, well then dial *6
Then what?
*6
Star 6
And it comes across as private.
on private.
I thought it was 6 9.
Can I continue what
Yes,
sorry.
go ahead.
today?
Sorry.
Although I love hearing about all of this as well, and it certainly is relevant. Jonathan, your hand was up too.
No, it's not.
Oh, I'm afraid to speak. No! Notice to the parents. You know what's important about that paragraph? So when these cases first started, before 1994, a case that was started like this, the worst case scenario for parents was only losing custody. If the department at that time had made a determination, service plan after service plan, you know what, these parents are unfit, they're always going to be, we need to free the children for adoption, the department would have to go to probate family court for termination of parental rights under Chapter 210. well, after 1994, the legislature changed the statute, changed 119 and 210, so that actually a juvenile court judge would now has the ability to not only find children in need of care and protection, but dispense with parental consent to adoption. So that's why the notice is now sent, and it's right in the middle of the paragraph. It says the summonses shall include notice that the court may dispense with the right of the parents to notice of or consent to the adoption of the child, blah, blah, blah. So the parents are getting not only notice that this is a care and protection proceeding in which they might lose custody if they're unfit, but the notice is also giving the parents the worst possible scenario that they could lose, lose altogether, totally, their parental rights as well. Good that it's giving notice, but it did make the proceedings in juvenile court after this much, much, much more adversarial. You're getting notice like this as a parent, and then you're told that you need to work with the department on service plans, which, it's can put the parent certainly at a point that the parent may not want to work with the opposing side to give them ammunition to terminate parental rights. But in any event, that's the notice part of the statute. And again, so then we're back to paragraph 3, which was the emergency hearing, and the standard being reasonable cause. At the end of that third paragraph, the mention is of the 72 hours. Okay, so that emergency hearing in which the judge says, okay, custody to DCF lasts technically for only 72 hours. What does that mean? Well, first of all, on the day that emergency custody is given, the court also appoints people. Okay, so under the statute, parents get counsel. Amanda, tell me why do parents have a right to counsel in a care and protection case?
Because they have rights.
Oh, I was looking at the other Amanda, but you can answer.
Sorry.
Go ahead.
Because they have rights for themselves and as the parents of the children.
Yeah.
And they need to be represented.
Yeah, you got it. Yeah, it's the cases that you guys already read. You have the right to, rear your children. You have the right to, basically, to custody of your children. And when you have, the state coming to interfere with that right, it's not an absolute fundamental right. There's a U.S. Supreme Court case, I don't think it's in your readings, Lassiter versus Department of Social Services, that basically says that that parent didn't have a constitutional right to counsel. Massachusetts, and actually most states, in cases where parents are in danger, of losing custody of their kids, courts, but usually by state statute, will appoint, counsel for parents. In the situation I just gave, Laura and her husband, Laura and her husband are married, right? What do you think about counsel for them? Separate. Everybody's saying separate. Absolutely separate counsel. And most of the care and protection cases, just by nature of the facts of the case, warrants separate counsel for parents. Children. And did you have to read the council article that, maybe it's not till later on. Hold on. In the syllabus. It might be later on, that's okay.
Just say that in most circumstances it's separate counsel, or it's automatically always?
It's not automatic, but
Most circumstances
in most of
require
the
it.
situations of care and protection cases, many times you have unmarried people, many times you have, multiple fathers, many times you have domestic or sexual abuse, or an offending parent and a non-offending parent, etc. So the judge can tell pretty much from, you know, the application itself, the petition itself, the affidavit itself. What gets a little bit tricky, and we'll talk about later on, in role of counsel for children. I'm really not going to get into it right now, but I'll just throw it out for you, and we will talk about it in more detail, that children could have a specific differing interest. And so sometimes you get an attorney for, you know, all 3 kids. Sometimes you get attorney 1, attorney 2, attorney 3, again, depending on the interest.
So you could have half a dozen attorneys.
Oh, yes. Oh, yeah. When you guys come to observe, and if it's a care and protection case, you're going to see more, you know, professional people in the courtroom than parties. So I started to say that on that day, when DCF got custody, the emergency hearing day, the judge that day will give, fill out the sheets, notice of, you know, counsel for father, counsel for mother, counsel for kids. Also will appoint under the statute, and we'll be talking about this in more detail, a court-appointed investigator. So that's not what I just talked about, the investigator under 51B. This is a totally separate, objective person. Most of them are attorneys that have gone through a training, that are appointed by the court. Sort of like, I think of it as an arm of the court. The judge can't really go out and see everybody and talk to everybody. So that's what this investigator does. He or she makes a report to the court of the facts of the case, and that's usually about a month later, okay? So think in terms of this time frame. Getting back to the time frame, so on Monday, parents get appointed, but parties have a right to come back 72 hours later for this hearing on the issue of custody. And it's your right under the statute. You can waive that right. You can postpone that right. And sometimes, and actually many times, it happens that the 72-hour hearings get postponed. You're an attorney, you get appointed, you need to be able to talk to your client and prepare for this 72-hour hearing where they're going to come, you know, to, you know, see what DCF has for evidence to keep that custody order going, so they might need more time to confer. But under the statute, if you're following the statute strictly, it has to be done within 72 hours. Many of them are not. Many of them are like months later.
Can I just clarify? So the hearing is automatically scheduled for 72 hours later unless waived or postponed, or the parents have to exercise that right to say, I want that hearing in 72 hours?
No, you're going to... how do I put it? There's an order of custody that issues relative to the emergency order. No, the 72-hour hearing is not automatically. However, parties are going to appear and they're going to tell the court. They may have a stipulation, you know, in lieu of 72-hour hearing. They may come in and say, you know, we need to have this 72-hour hearing next Friday when all counsel can appear. Next Friday comes around, somebody asks for a continuance. So again, strictly speaking, it would be automatic and it would be 72 hours later.
But
It doesn't necessarily happen that way for many reasons. Court docket, attorneys, parties not being available, etc. Parties telling the court, you know, we think we can stipulate, can we have until next week, etc., etc.
All right, so I get all that. I just am wondering if at this emergency hearing, so the judge issues custody to the
There's
state.
going to be, every time you're in court on these cases, you will know when the next court date is.
Okay, so
So
they're
that
gonna
next
schedule
court
it.
date might be, it should be 72 hours, you know, a couple of days later, Whether anything happens that day depends.
So whenever the
Yeah.
hearing actually happens, it is something scheduled by the court. It's not something the parents have to say, I want this hearing, or it never happens.
No, because
You
on
have to
that,
request it.
parents may not be around.
Right.
And that's, parents may be in jail. Parents may, for whatever reason, feel so hopeless about the legal situation that they just can't cope enough to meet with an attorney and to come up with, I don't want to say a defense, it's not necessarily like a criminal case, but to come up with, what we're going to do here, what our legal strategy will be. But in any case, once and if this 72-hour hearing happens, now we're upping the ante because DCF got custody. DCF was able to remove the kids because of an emergency. DCF got custody Monday morning because of an emergency. Now we're 72 hours later. Now DCF has to convince the court in order to keep that temporary custody going, has to convince the court further. And this gets into some of the case law, and I'm wondering, we're a little bit early, but I might. Well, I'm going to go over it, but I want you to read the cases, and we'll review again on Thursday. So notice that reasonable cause to believe was the standard for the emergency hearing, but if you look in this paragraph, it doesn't say what does the court have to be convinced of at the 72-hour hearing, okay? So there is a standard, and it's in the Robert case that I gave you for reading for Thursday, and the standard is preponderance of the evidence. So DCF has the burden. If there is a 72-hour hearing, DCF has the burden to show that continued, if the child were placed back in the home, the child would be in danger of abuse and neglect. And they have to prove that under the ordinary civil burden of preponderance of the evidence, which is pretty low, but not as low as reasonable cause. So some of these 72-hour hearings are full-fledged trials. Opening, direct examination, cross-examination, exhibits, other witnesses, etc. But DCF has the burden of proof, and it's the Robert case. I'm just trying to think if there's anything else I want to say to you about Section 24. Let me skip to 26 in the next few minutes because 26 is the trial itself. So again, 24 is the beginning of the care and protection case. Again, Section 24 had the reasons why DCF would file, has the notice to the parents, has the standard for the emergency hearing, and mentions the 72-hour hearing. Whereas Section 26 is the trial, the adjudication, and the disposition phases. And I'm going to go through it real quickly, and we're going to review everything again on Thursday, but in the context of the cases that you have to read as well. Notice that up until now, I didn't say anything about the children in terms of them being parties. Obviously, it's care and protection of, Amanda Phillips, for example, if she's the child. It's not, Commonwealth versus, Laura Lowry. It's a care and protection case about a child. And it just so happens that because parents have custody of children, they become parties as well because they lose custody as a result of being unfit to care for their children. So Section A of the hearing, of the Section 26 says, if the child is identified by the court. So that all it only has to happen once. Children have to be brought in, or if they're really seriously injured, the judges have to go to the hospital. So the child has to be identified. So a worker would bring them in, judge would say, oh, hi, how are you, Amanda? How old are you? Blah, blah, blah. Bye, see you later. So for the most part, you're not seeing the children sitting, through these proceedings, because obviously they're proceedings that, even though they're about kids, the kids should not be sitting and watching them and hearing what's going on. So that's what that Section A is. Section B deals with the adjudication. If the allegations have been proved within the meaning of this chapter, the child is the court. So if DCF meets its burden of proof at the final hearing, so one emergency, 272-hour hearing, this was section 24, this is section 26, the trial, the adjudication phase, the judge would find children in need of care and protection. And again, as I said before, DCF, having been the petitioner, has the burden throughout here. And if you look through 26, just like the 72-hour hearing, the standard of proof isn't there. It's case law, and it's some of the cases that, again, that you have to read for Thursday. The U.S. Supreme Court of Santosky versus Kramer set the standard for trial of a case concerning children that have been abused or neglected. And the standard is higher than, it's higher than reasonable cause, it's higher than preponderance of the evidence.
It's clear and convincing.
It's clear and convincing evidence. So because these are not criminal cases, nowhere do they proceed and go up to that number 10 that I mentioned before, proof beyond a reasonable doubt.
So that you would say was somewhere like on a scale of 1 to 10, like a 7 to 9?
Exactly. And also the Robert case, the Massachusetts case, has a really nice discussion of the standards of proof. Santosky, not so much. You know, you're going to get the standard out of the case, but you're not really going to get a lot of guidance as to what clear and convincing really means. I think that Robert, the SJC, does a better job at it. I'm going to leave it because I'll rattle on and take say too fast all the possible dispositions, and it'll go in one ear and out through the other. So we'll come back to this, the dispositional, what in it. And what do I mean by disposition? It's once I find these kids in need of care protection, what do I do? So we'll come back to that and read the cases for Thursday. What question?
No, I just was going to point out, it was interesting to see the difference from the article about how the parents really don't have to get a whole lot of notice on the 51A part of the, but once it gets a little further along, that's when it sort of kicks in.
Exactly, because we're going to
There's more at stake,
procedural due process right.